Good afternoon, everybody. At our live session today, we're going to chat about wills and the importance of having a valid drafted will. I'm just waiting on a few more people to connect, so we'll just give it another minute or so. Please do post a comment in the live box in your questions so that I know that we've got audio working and visuals working. Please feel free to answer any questions at any time, and I will gladly answer those as I go through. Let's see here. Just having a look to make sure. It looks like everything's broadcasting nicely. I hope you can hear me well on your side. So please do post comments. I can see them. I might not respond immediately, but I will keep an eye on them, and I will go through them and answer those for you as we go through the session today. So I think it's probably best. It's just gone over 1:30. I wanted to start at 1:30, so we'll stall for a few more seconds and just to let people log on and let the comments start coming through. So I will obviously look down from time to time. I have made a couple of notes of things I want to discuss and share with you. And like I say, we'll keep this a nice, short, informative session. And I'm looking to have these on a more regular basis. So please do let me know what topics you would like me to chat about and what you would like to get involved in the conversations. So let's start. What is a will? So a will, in my opinion, is your most important financial planning document. This helps you transfer your legacy and your assets to those that you love and care about. And is there nothing more important than that? Making sure that what you've spent your life creating and putting together, that can get passed on to people that you want. I see we've got a couple of people posting comments. Thanks very much. I'm glad to hear that it's all working. So a will is a legal document. And with that in mind, this is why I feel and highly recommend that you don't make use of a DIY will. Don't download a template. Don't try and create a will based on what you've seen, heard, and others have told you. As mentioned before, it's your most valuable and most important document. So it should be drafted correctly. And there's so much to consider when drafting this document. So you wouldn't want it done by someone who's not quite sure of all the considerations to take when creating your will. Your will is there to express your wishes when you are not here. It's your voice when you're not able to speak. So it's very, very important to make sure that what you put in your will is clear, concise, it's not ambiguous, and that it's implementable. It must be something that your executor, and I'll get to that person in a moment, is able to actually carry out your wishes and your instructions. And that's why you need a knowledgeable person, a professional, to help you in drafting your will. In that will document, it's going to set out who inherits your assets when you pass away and if there are any conditions. Now, you've got to be careful with this one, is you can't be seen to be ruling from the grave. So your conditions can't be to further control your assets when you are no longer here. They have to pass to your beneficiaries. But I'll give you a practical example of a condition. Minor children are unable to receive their inheritance. Just imagine a 10-year-old getting 2 or 3 million rand. They wouldn't know what to do with it. So the condition that you can put in your will is that that money is for their education, to look after them, so to provide them somewhere to live, food, holidays, clothing, and to look after them as if you would have done so should you have still been alive. And at a particular age in their lives, that money now is available to them in full, provided there's some left over. And I'll come to protection mechanisms of that in a moment. You now get to nominate your executor. Now, I'll do a little bit of jargon busting. Your executor is the person who now will take your will and be able to execute what it says within. So they, in essence, take your persona, they become you in law, and they now have to carry out certain duties and obligations. And then once those have been done, such as paying off debts, paying taxes, closing accounts, um, they are then able to action the items you have put in your will. This person, once again, should be someone that's knowledgeable and experienced in winding up of estates. And I'll come on a couple of considerations to bear in mind with that. But nominating someone who is not knowledgeable and not experienced in winding up your estate can create a lot of complications. It will delay the process. And it's rather, I think, unbearable for someone who's now grieving your loss. Do you want them, while still trying to grieve their loss that you're no longer with them, that they are now having to go to SARS and spend days sitting in SARS's offices, going to magistrates' offices, going to courts, going to transfer properties? It's a very onerous and burdensome task. And that's why it's important to make sure that you appoint someone who specializes in this. You get to nominate guardians of your minor children. So if you are not here, if both natural parents are no longer around, you get to nominate who should look after those children. It is so important that you give this such careful consideration. And most importantly, please speak to the guardian or guardians you have in mind. Make sure that they understand that you've nominated them, because it's a nomination. It's not an obligation for them. I'll touch on this a bit further. And then, as I mentioned, you have the testamentary trust provision for minor children or for those that can't inherit. Perhaps they're mentally or physically disabled, or they wouldn't have the capacity in law to be able to manage and understand the inheritance that they have received. And that's why we would recommend, or I would recommend, that you make use of what's called a testamentary trust. Now, this trust is not set up today, and there's no cost to make the provision for this trust today. It is a clause in your will that it is established only on the passing, and that it is there to look after those nominated within it for their benefit until a certain age. Generally, for children, I would recommend not younger than 25. Some parents, and me personally, have made it 30. And this is completely up to you. I highly recommend against 18 or 21. I'm not sure about the gentleman watching, but if I received a large sum of money when I was 18, I probably would have bought a fast car, and we don't know how that would have ended up. So we need to think as responsible parents that we are. So that again bears burden to why you should consult with a professional. Now, what happens if you don't have a will, or you don't have a valid will, or your will, for instance, can't be found? You will die without one, and in the court's eyes, they have to now apply a law called the Intestate Succession Act. And this will determine how your assets are distributed. And basically, it follows a family tree. And it does get a little complex, and I'm happy to share that info with you. And please do pop me an email, and I will gladly send it through to you. But in a nutshell, this act will now determine who receives your assets. That could be the brother you no longer speak to, a cousin that's no longer in the family, or an estranged individual that hasn't been part of your life for many decades, now could become a millionaire. Is that what you want? So the court will then decide how that plays out. Your estate will be dealt with in this very rigid and inflexible structure. It's not very pleasant. And the big one here is your children, your minor's inheritance will be passed along to the guardian's fund. And it will only be available to them after they turn the age 18. And during that time, guardians can make application to the fund for maintenance costs. So that would be the schooling, the food, the housing, etc. Not sure about you. I'd prefer to have as little interaction with government departments as possible. Again, another massive one, especially if you're parents, to have a will in place with a trust nomination. So, recapping the advantages of having your will, that you get to choose your beneficiaries, you get to choose your executor. If you have children, you get to choose who looks after them and where their inheritance goes. And a massive one here, ladies and gents, is we can do estate planning. I'm sure you've heard this before. Death and taxes are the only certainty. Sadly, when you die, there are taxes too. There are certain exemptions allowed, and there's a lot of complexity when it comes to estate planning. So that's again why it's so important to consult with a professional and make sure that it is set up correctly. So that in a nutshell is a bit of a discussion around wills. If you have one, please make sure that you review it. If you don't have one, let's get you drafted one. Couple of interesting points and sad ones. And two, unfortunately, only about 20% of South Africans have a valid will. I've consulted with many clients who have a valid will. Some did it when they got married, and that was 10, 15, 30 years ago. Things have changed. Don't consider your will a static document. It is something I highly recommend that is reviewed at least every 2 to 3 years, but especially in life events such as marriage, divorce, death, and the birth of a child. Those call for you to review your will and make amendments where necessary. Important consideration, like I mentioned before, the executor nomination in your will. You can appoint anybody you wish. However, the master may decline your friend or spouse as an executor because they must have the will, the skill and the ability. They must be a professional. And imagine again that emotional burden on your spouse trying to wind up your estate and dealing with people that perhaps don't have as much empathy and compassion. Again, Guardians Fund for Children. It ensures that your money is protected by making sure you nominate a testamentary trust in your will for minor children. Those that you nominate as a guardian, again, must accept that nomination. And here's a very, very big one. That guardian nomination must be practical. I want to give you an example. Mom and dad pass away, there's a little child, and the guardian nomination is dad's sister. Dad's sister lives 1,000 kilometers away. So I'm in Joburg and the sister's in Cape Town. But dad's sister is a medical student. She's studying to become a doctor. She works sometimes 24-hour, 36-hour shifts. She's studying continuously. It's firstly geographically impractical because now this poor little child is moving provinces and towns away from people she may know, schools that she's used to, friends that she has, to someone who potentially can't actually look after at the moment because their life doesn't allow it. So consider your practical implications of a guardian nomination. I've also had this before where obviously it's a tough one, guardian nominations. Mom goes, I want my parents to look after little child. And dad said, well, I want the same. Ladies and gents, will both sets of grandparents move into one house to look after this child? Or will the child have to go between the two homes on a continuous basis? And to further complicate this matter with this family I consulted with a while back, mom's parents don't even live in South Africa. Again, the geographical ramifications of a guardian nomination is so, so important. And lastly, all debts, fees, and taxes, as well as marital contracts, must be paid first before anyone else in the will can inherit. So all debts must be paid, all fees must be paid, all taxes that are due must be paid. And depending on how a person may be married, so that's in community of property or an antenuptial contract, but with the accrual system, has to be paid first before anyone else can receive their inheritance or their benefit from that will. So please keep that in mind when you go, well, blah, blah, we'll get my house. Possibly not practical. Legally can be put in a will, but can it actually be done? So we need to test that. And I know I said lastly, but the very, very last, keep it simple. Rather review your will regularly, but keep it simple. You want to make sure that this will is simple, but encompasses everything that you require, so that when your executor has to execute the will, it's easy to do so. I hope that was beneficial to you. I haven't noticed any questions pop up. Like I mentioned, I want to do this on a regular basis. So, from the audience that's with me at the moment, what topics would you like to see in future events? And did you find today's informative and valuable? Please feel free to post a comment. Please watch out on my Facebook feed, Twitter, LinkedIn. We also have a YouTube channel. The links to all of these are available at terencetobin.co.za. So do follow, do interact. I love to hear from you, and I hope that you have a safe and wonderful lockdown. Take care.